Hi, my friends. Today we're going to discuss contracts and we're also going to look at commercial law in general. There you can see a signed contract, and yeah, sometimes if a contract is not signed, it's not enforceable. And we will look at all these different things because often even an oral contract is a contract. But I don't want to run ahead of my story. Let's continue. The most important act that's basically controlling, managing contract law is the Contract and Commercial Law Act of 2017. There is no other law that is more important with regards to contracts. And I've taken you a screenshot of it, and there you can even see the link, the legislation.government.nz. If you're a New Zealand citizen, you can access it for free, and basically all acts, all pieces of legislation, you can find it on this website. I've just opened section 3 of this act, and it's all about the purpose of this act, and there you can read it. The purpose of this act is to reenact in an up-to-date and accessible form certain legislation relating to contracts and the sale of goods. In other words, if you want to sell goods, you need this act. And we will see there's a difference between goods and services. And electronic transactions and the carriage of goods. If goods are transported, who's going to be responsible for it? All those answers that you will, all those questions that you will experience during contracts, you'll find the answers over here in this act. It's an amazing act. It's a consolidated act. And also various other commercial matters. We know that the moment that there's commerce, the moment that people are involved in transactions where there's money and value involved, it will always have repercussions. And including mercantile agents. In other words, we're also going to look at agency. What agency is, because we know that there's a lot of transactions taking place, even though we've got valid contracts, but we also make use of agents, and those contracts should also be in place. And we're going to look at agency and how it's affecting our contracts. I simply love this act because whenever you've got questions regarding contracts, it's like a one-stop shop. You can just go to this act and you will get your answer. And the reason why I love it, because some legislation were old and some of the words was really difficult to understand. So it replaced legislation. Some of them were more than 100 years old. So it renewed basically 11 New Zealand statutes relating to contract, and including the sale of goods, electronic transactions. I can maybe quickly read it to you. The old act was the Contracts Privity Act of 1982. Listen, contracts, privity. Privity means the different parties involved in this country. Of 1982, it's now portion 2. Subportion 1. Electronic Transactions Act 2002, the Carriage of Goods Act of 1979, Contractual Mistakes Act of 1977, the Contractual Remedies Act of 1979, the Frustrated Contracts Act of 1944, Illegal Contracts Act of 1970, Sale of Goods Act of 1908, the Miners Contract Act, the Sale of Goods, United Nations Convention Act of 1994, all these things are now consolidated in the Contract and Commercial Law Act, and you can find it as different parts or different portions of this act. The Contract and Commercial Law Act of 2017 was also the first act passed under Section 35 of the Legislation Act of 2012. So Section 35 of the Legislation Act of 2012 basically said, rather than making new law, we should make law more user-friendly. So that's part of this purpose, people, because the amount of legislation that's yearly promulgated, it's so extensive, and it's kind of like we don't know where to go. So sooner or later, we had to get something like this where we try to make law more easily accessible and understandable, and not so many laws. If there is to be any change to existing law, this must be expressly stated. Okay, here I've decided to put this PowerPoint slide in for you so that you can see exactly, you can look at the old legislation and which parts, if you go to this, the Contract and Commercial Law Act of 2017, you will see the exact part or the subpart where you will find it. Let's take, for example, let's look at this Sale of Goods Act of 1908. If you want to know more about the sales of goods, you can find it over here in the Contract and Commercial Law Act of 2017, and it will be part 3, subparts 1 to 6. I hope that's clear to you, because you will definitely need it. I think even if you can make a copy of this slide or a screenshot, it's very, very handy to have near to you. We talk about agreements and we talk about contracts, and often it's just synonymous, but it's not really the same thing. So I want to ask you, what is the difference between a contract and an agreement? And before I give you the answer, I want to ask you another question. What are acts of God? We believe that God is love and God is good, but in law, in the world systems, God is always blamed for all different kinds of things that go wrong. So I just want to give you a hint with that. What are acts of God in law? People, normally, we are supposed to keep our agreements. We are supposed to live from transparency, from honesty, from sincerity, from good faith. Unless there's force majeure, it's the French word for greater forces involved. In other words, where it's out of our control, then we can have like a legal exception for why we did not perform what we were supposed to do. So for example, if there's like a terrible earthquake or a volcanic eruption or a tsunami, all those things that we in law basically call acts of God, it can relieve, for example, a landlord from his obligations. If he had, like, say, for example, a lease agreement or a rental agreement with somebody for a certain period, and he can't stick to that based on this acts of God because it's out of his control. But except for that, you are supposed to stick to your agreements. And this is coming throughout history. If you go all the way back to Roman law, they had, like I say, pacta sunt servanda. Pacta, a pact. Pacta sunt servanda is the Latin for agreements must be kept. Not should be kept, must be kept. It is a basic principle of civil law and of international law. Just think for yourself, if we just behave, we don't stick to our agreements, we never keep it, it will be total chaos. You can't reckon, you can't trust anybody. It's actually already a pity that we have to write it down. So it's a Latin word for agreements must be kept, and it's a basic principle of both our civil law and of international law. In common sense, the principle refers to private contracts and implies that non-fulfillment of respective obligation is a breach of the pact. It's a breach of that formal agreement. In civil law, it's the general principle of correct behavior in commercial practice. And with reference to international agreements, every treaty in force is binding upon the parties to it, and it must be performed by them and in good faith. So pacta sunt servanda is related to good faith, but it's not 100% the same as good faith. People, even today, our courts continue to confirm the commercial principle developed in Roman times. Pacta sunt servanda. It simply means your agreements or pacts must be kept. Business people rely on agreements. I mean, if you buy a car and you've paid for it, you rely on that person to deliver the car. You've paid for it. You've got a right receiving it because you fulfilled your obligations, the payment. Okay? So that person has got an obligation as well to deliver the car or the whatever capital goods we've got in mind. I've got a clip over here, a video clip, which is really good, understanding good faith. But there you will see that it's all about transparency, honesty, sincerity. And sometimes people can say, but you know what? It's due to incompetence. I didn't know, I didn't have the right kind of knowledge or the right kind of training, and that's why I behaved the way I did. And that's why there's also an objective component to good faith. And that's why if somebody is like an engineer, you expect that person to behave according to the standards of a qualified engineer. You expect that person to be able to do his job. The same with an accountant, because we are all in accounting or in commerce. So agreements are verbal or written, but it's not enforceable by the law. So agreements, where it's different from contracts, it's verbal or it can be written, but it's not enforceable by the law. But contracts are agreements that are enforceable by law. Contracts contain certain elements or ingredients that agreements do not have. Often, when I ask students if agreements are enforceable, then they will say only if it's in writing. But people, no. Then I realize they are still confusing contracts and agreements, and then I'll ask them, what about contracts that are just oral? If it's just an oral agreement, is that enforceable? And then they will say no, but it is. If all the elements are in that contract, it is enforceable, even if it was oral. Of course, because of evidence, we want stuff in writing, and certain contracts, there's like a requirement that it should be in writing. But we will soon get to that portion. So there's basically certain essential components of a contract. There should be the different parties, and then a certain price, the business that they're going to buy or the main duties and obligations of the parties. That's all the essentials of the contract. It should be mentioned in the contract. So we've got certain standard clauses in the contract that require further explanation. For example, you'll often find stuff in contracts like, or terminology like stock in trade, or a restraint of trade, or dispute resolution. And we're going to look at all that stuff, but you will see there's a lot of terminology, and unfortunately, you have to know them, especially the more important ones. People, there's different ways to teach contracts, but basically, a lot of people teach that there's 6 requirements for a valid contract. So, first of all, the parties must have like the intention to be bound, to be legally bound. If that intention to be legally bound wasn't there, if it was absent, guess what? There's no contract. Okay? Then it's not a contract, it's just an agreement if the intention is absent. So there must be agreement as well. In other words, what we mean with an agreement, there's 2 elements that we always look for. There must be an offer. One person must make an offer, and the moment that the other person accepted that offer or accepts that offer, there's like an agreement. And then what we also need over there, because most of the times when there's like no legal contract formed, it's because of the absence of consideration. We will look at consideration, but consideration is something like money. It's value. There should be a certain kind of like value on both sides for both parties. One party can't profit on his own. If you go back to the Roman law, when I studied Roman law, there was this story about the lion who made a deal with all the animals, and they should hunt together, and then they all had to give him half of the things that they caught. So it was a nice agreement between lion and all the individual partners, because he was basically the only one profiting from this agreement. So a society's leonina, like they call it, it's not the law. In law, we will never see that as a contract unless it's in a very specific format. In other words, you can promise stuff to people, and if we put it in the if we use the right documents, and then we can basically do that, but it's not a normal contract. The parties must have like capacity. In other words, they should be sober-minded. They must have like the compos mentals, the mental abilities to understand what they are doing. They shouldn't be drunk, they should be sober. And there must be genuine consent. In other words, I want to do this. I'm giving my yes. I really want to. You are not forcing somebody. And the agreement must be legal. In other words, you can't agree contractually to do something illegal or do something in an illegal way. In last week's class, we spoke about property, and we've looked at realty and personality, different kinds of property. But with regards to the form of contract, often there can be a very specific requirement as to the form of the contract, and specifically when the contract deals with fixed property it must be in writing. Okay, people, because there's always like different requirements. Here you can see, for example, we get tangible assets. It's assets that you can physically touch. There we think about property, vehicles, machinery. And then we also get intangible assets like brand names, trademarks, copyrights, goodwill, patents. The essential elements of ingredients for a valid contract, here we can look at it, and I've already told you, first of all, if somebody made an offer, and the moment that that offer is accepted, that moment that somebody accepts that offer, then a contract was formed. A legally binding agreement. That's basically what a contract is. It is an agreement, it's a type of agreement, and it's legally binding. Okay. Then acceptance is if you agree to the terms of the offer. And that's why if you like a lawyer, if you're a good lawyer, you will always make use of what they call the mirror principle. In other words, you will make sure that everything that that person addressed in his offer, that your acceptance, then you say, okay, I've offered my yellow house with a brown roof for $50,000, and you can basically take possession on that and that date, and then you say exactly the same thing. I accept that yellow house with a brown roof for $50,000, and I will take possession on that date that you mentioned. You just make sure that you mirror everything that was in the offer, in your acceptance. So consideration is the payment, or it can be a benefit that's got value, and the intention to be legally bound. If you had like the intention to be legally bound, there will be a valid contract. In other words, offer, acceptance, consideration, and the intention to be bound, legally bound, there is a legal contract, a valid contract. Once you have a legal and a valid contract, the law will step in and help you with the interpretation of the terms, or look at whether the parties should be protected in some way, the parties to this contract, and determine what happens when a contract finishes, in other words, when it comes to an end, especially when there is a disagreement between the parties. And this is what is usually happening. You get a contractor to do some work for you, and along the way a dispute will develop, and he will maybe not finish the work, or he already finished part of it. What's going to happen now? This is where we need law, and where the law will step in. And it will provide us with the remedies available for somebody who is unhappy with how a contract has ended. It's extremely important that there must be consensus. There must be consensus. In other words, parties must have the same thing in mind whenever they're busy forming a contract. In other words, the Latin word for that is, we want consensus. We do not want disagreement. We want people to be in agreement. So you will tell me, but Jay, that's so easy. So what about it? You will be amazed how easy it happens, how easy it can happen, and how often it happens that people think they are in agreement, but they are not. And this is simply because we are human beings. And now I want to scan through a few slides, and the moment that you see those slides, just tell me what you see. And you will be amazed that there's always somebody else that's seeing something different from what you see. So the first thing that you saw, mention it. And then if you probably watch a little bit longer, you will see, okay, it could have been something else as well. And this is what law is all about. It's about the interpretation of words. And the moment that you hear words, you form a certain concept in your brain. And it can be totally different from somebody else. And we want it to be in agreement. We want the two parties to be in agreement. People, this is a really good one, because often people from the Jewish faith and Christians will think that there's consensus. In the meantime, they totally differ. There's absolutely no consensus, even though it sounds like the same thing. And that's why often even the religions will be confused. So what we want consensus ad idem. And it literally means a meeting of the minds. The minds of the two parties involved in this contract must be in agreement. Because remember, there's always two parties to an agreement. People, can you remember I've been talking about the handshake and the law when it's necessary for the law to step in. And just look at that picture. A picture is saying 1,000 words in the corner. But there you can see how somebody's trying to help two parties to reach an agreement. So remember, we said consensus ad idem means there's a meeting of the minds. There must be evidence of the parties reaching an agreement to be contractually bound. If you had something in mind, I had something totally different in mind, there's actually no agreement at all. In Attorney General versus Barker Bros Limited, the Crown leased an airstrip. The defendant wanted a substantial increase in the rental amount. He therefore wanted to cut the Crown out and said, there was no consensus. But there was a mechanism to obtain consensus, as there was a clause to arbitration in the contract. So in other words, what he said, because they didn't agree to a fixed amount, the consideration, he said, there's basically one element missing, and therefore the contract is not valid. But there was a clause saying that it will be sorted out using arbitration. So we can use arbitration, we can use negotiation, we can use mediation, we can use conciliation, we can use facilitation, all to get people to think the same, to be in agreement. We can do this all for a meeting of minds to take place. And you will see, we're going to do it later, but we call it alternative dispute resolution. In other words, we don't necessarily have to go to a court. We can basically help people to reach consensus or meeting of the minds, even outside of the court. And people, this is an age-old tradition, and even in Africa, and even some of the American Indian tribes, they used to have like a stick principle to reach consensus. In other words, if I've got the stick in my hand, I'm allowed to talk. You're only allowed to listen. And then I hand over the stick to you, and then you're allowed to talk, and I'm not allowed to interrupt you, because most of the times people interrupt each other, and that's why conflict are seldom resolved, and often people never find that place of consensus, meeting of the minds, peace, harmony, what we strive to obtain in law. It's interesting, if you read on this slide, everything is, and it always was, about offer and acceptance, while at the same time there should be a meeting of the minds, one-minded. This is not what I mean with an offer. This is a good example of a unilateral offer, and we will get to unilateral offers, and then you will understand what I mean. You open a book, you see a certain advertisement. They are advertising a certain article that you really want at a really low price. So you are so excited. Immediately you run to buy it. And the question that I want to ask you now, if you see this advertisement, is it an offer? Does it mean that the moment that you accept that offer, that price, that there was like a transaction, an agreement? I want you to think about it and give me the answer. Maybe stop and pause for a moment and think about it and make up your decision. Is an advertisement an offer? Yes or no? Okay, people, we are just discussing one ingredient of the substances or the different ingredients that is making up a legal agreement, or a binding or a valid agreement, a valid contract. Okay, so the first ingredient, ingredient one, there should be an offer. So we already said, if an offer is made and it is accepted, then a contract is made. Unfortunately for us, if we look at advertisements, you will probably say, yes, that was an offer. But the best example that I can give you to show you that it's not really an offer is an advertisement for a certain position, a job advertisement. If you see they are advertising a certain job and they are willing to pay this guy like $70,000 per annum, and you realize, oh, this is a real good opportunity, you can't just storm into that place and say, I'm accepting the offer. It was never an offer. It was just an invitation to trade. That invitation or that negotiations can lead to an offer, but it's not an offer in itself. So with regards to contract law, people can basically advertise something at a certain price and not give it to you at that price. Of course, when it comes to consumer law, we can take them on using the Fair Trading Act, but that's something totally different, and we will come to that. But as long as you see that an advertisement is only an invitation to come and negotiate. Interesting court case happened in Harvey versus Facey. The court found there was a supply of information about the property and not an offer that could be accepted. So it was still in the days when they used like telegraphs to send each other like telegrams, telegraphic info. And so what happened, this guy wrote to his friend Harvey to Facey. I can't remember which way it happened, but it was Harvey asking Facey, how much are you willing to accept for your farm if you should sell it? And then he was giving him, he gave him a certain amount. He said, that's an amount that I will accept. And so immediately he got a reply, a telegram saying, I'm accepting that amount, deal. And then he went to court because he said, no, I never made an offer. I only answered your question. I said, I will accept this amount. That was the information, but I never had the intention. I wasn't even thinking of selling. And at the end of the day, this is what the court found. There was a supply of information about the property and not an offer that could be accepted. If an offer is one of the ingredients of a contractual agreement, we should look at how offers are made. What's the requirements for a valid offer? So first of all, offers can be in writing, like signing a sale and purchase agreement. So that's very good for evidential purposes if we've got something in writing. But remember, verbal contracts can also be enforced. It's just more difficult when it comes to providing evidence. And one of the ways that I'm thinking of is like at an auction. You can make an offer at an auction when you yell out a certain amount. I'm willing to pay this. You're making an offer. So if they accept it, there's a deal. Okay. And then conduct, you can walk into a shop. You're not in the mood for talking. You buy there every day. You just point to the lady. She said, can I help? You just point to an article. Say, you want one of these? You just nod your head. And she's basically giving you the item and accepting the transaction is going through the till. You've got your cash slip. You walk out. You never said a word. Everything was conduct. Or it can be conduct. It can be verbal, oral, or it can be in writing. A combination of it all. Okay, so that's how offers are made. People, you will be bound to an agreement if you had the intention to be legally bound when that original agreement was formed. So you should ask yourself, is this person that's supposedly making the offer really intending that once accepted, there will be a contract? If you can answer yes to that, then there will be like the intention, or if you had that intention, you will be legally bound when that contract is formed. Otherwise, often contracts are not enforceable if the intention were not present. If someone advertises a product or service for sale at a certain price, it is only an invitation to treat. We've already said that. And there's several cases in the international law, even Patridge versus Crittenden, where this was confirmed. So all over the world, people are in agreement with this, that an advertisement is not really an offer. It's only an invitation to treat. But remember, under the Fair Trading Act of 1986, you are not allowed to make any of these false misrepresentations. And you will get problems because you will be in breach of the Fair Trading Act. So make sure all the terms are contained in the offer, if you make your offer, so that if it is accepted, it will show all the terms of a contract. And remember, there can be no contract unless there's sufficient information, like the price or the method to calculate the price, because remember, we already said consideration is one of the elements of contracts. And then look at my picture. Remember, invitations to trade are not offers. Advertisements are not offers. So the next time you see that job advertisement, remember, you first have to go to an interview so that it's an invitation to treat, to negotiate. And only then the job will be awarded to you. You can't just accept it and then take the people to court. It's crazy. Just the idea is crazy. And exactly, you should think exactly the same, in the same way when you think about contracts where goods and services were advertised at a specific price. You speak to one of your friends and he's telling you that he's thinking of selling his car for $750. You realize it's a bargain and you tell him, listen, I'm interested in buying your car for $750. Later, when you see him 2 weeks later, you realize, okay, he sold his vehicle to somebody else for $750. And you are kind of like agitated. But he never realized it's an offer, that you've actually made an offer. He thought you are just providing him with information. Yes, I'm willing to, that's information. You were sharing your heart, but you were not really making an offer. So to establish whether an offer was made, ask yourself, would a reasonable person believe they are receiving an offer or not? If yes, there's an offer. If a reasonable person will believe, yes, if I listen to everything that is put here on the table, I can see his intentions. Otherwise, it's just a supply of information. Acted in a way that another person was convinced it is an agreement, and then you acted accordingly. In Smith versus Hughes, this was an interesting case. It was decided that Smith was entitled to be paid for green oats. Smith argued that even though there was a misunderstanding, there was still a contract. So, what happened in this case, Smith took some green oats to Mr. Hughes. And he said, are you interested, a sample. He said, are you interested in buying oats? So Mr. Hughes was like a horse farmer. He said, of course. But horses do not eat like the green oats. He needed like the real stuff, the ripe stuff. And so he looked at the sample and so on, and he ordered it. And then he received this green stuff, and he couldn't do anything with it. So he wanted to cop out of this agreement, and he said, no, I never had the intention to buy this green stuff. I can't use it. So he said there wasn't an offer. So in the court, it was decided, no, it was about oats. The quality of the oats do not matter. The thing that we have to look at here, Mr. Smith he provided you with a sample. You saw the sample. Mr. Smith didn't go in there to lie. He told you it's oats. And everything at the end of the day, all the evidence was against Mr. Hughes. And at the end of the day, he couldn't just get out of the contract. He had to pay Mr. Smith. So remember, Last week we talked about it. There's that closure, caveat emptor, caveat emptor, Latin phrase, caveat emptor, as long as you spell it correct. Buyer beware. In other words, before you buy something, make sure that you know exactly what you are buying. Okay? There's also another thing that we get, caveat emptor. In other words, a seller must also be beware, and that's why if you put stuff on TradeMe, you have to put the photos there so that people can see the damaged marks on your car and so on. You have to expose those faults so that the buyer can see it. Because if you are not going to expose it and just say, oh, this car is in excellent condition, whatever it is, and the guy who's going to buy it is going to see that there's dents on the car, you've never told him about it, you're going to be responsible for it. He's going to take it to a panel beater who's going to fix it, and he's going to claim the damages from you. The action for misrepresentation failed as silence from his part could not be seen as a misrepresentation. This was in Smith versus Hughes. The defendant did not mislead the claimant to believe they were old oats. He didn't tell him it's old oats. Mr. Hughes just kind of like in his mind, he thought, okay, this will be old oats. The mistake was also not regarding the fundamental terms of the contract, but only a mistake to the quality. Race horses eat old oats, not green oats. So many people are talking about this, and we've already discussed it, the difference between ethics and law. It was probably unethical. I think Smith probably realized what was happening over there, but he pushed this transaction through, and this is where often we can see where ethics and law deviate, where it's not the same thing. But nevertheless, something to think about, but this is why you should communicate clearly in contracts. So this was a very controversial court case, Smith versus Hughes. But in this court case, the test of the objective person was introduced. And there the judge said the following: if whatever a man's real intention may be, he so conducts himself that a reasonable man would believe that he was assenting to the terms proposed by the other party, and that other party upon that believe he enters into the contract with him, the man thus conducting himself would be equally bound, Hughes, as if he had intended to agree to the other party's terms. So the reasonable man test, in other words, Hughes acted in such a way that from his conduct, Smith could basically believe he was entering into this contract. Remember, he gave him a sample of the green oats, and it was oats, and all the other ingredients of the contract was there. So, if there's any doubt as to whether there has been an offer or not, the court will look at whether the conduct of the supposed offerer, the person making the offer, would convince a reasonable person that they were making an offer. So in Smith's case, he was basically making an offer to Hughes, and Hughes accepted it. Okay, so this is what the court system is for. If you look at that picture of mine, there's the reasonable person test. In other words, the court system will look at it. Was Mr. Smith, was his actions, was it reasonable? Did he act reasonable? Yes, he did. He gave a sample. He said it was oats. This is the oats that I have. Are you interested in buying some of it? And so it's the courts that will determine what is reasonable and what is unreasonable at the end of the day. By following the reasonable person's test, in other words, if a reasonable person behaved in such a way that they basically gave me the impression, okay, I'm accepting whatever you've told me, like Hughes did on Smith. Smith walked away with that impression, okay, yeah, Hughes want this amount of green oats, then you will be legally bound. So we've already talked a lot about this now. So invitation to treat versus offers. One ingredient for a contract is the intention to be legally bound. So invitations are less than that. They are simply invitations to negotiate, to make an offer, not an offer in itself, even though it may lead to an offer. So that offer plus that offer, I've highlighted it in blue, plus acceptance, because it's what we are waiting for. Will that person accept it? And the moment that the other person accepts it, there's a contract. But of course, there has to be consideration as well. Offer, acceptance, consideration. There we have our contract. And of course, the intention. The intention to be legally bound. If those four elements are present, people, there's a valid contract. Okay, and I've found this on Google. Invitation to treat, not a proposal, but a sort of preliminary communication which passes between the parties at the stage of negotiation. So think for yourself, if I go back to that job advertisement, if they've offered 70,000 on that job advertisement, and now during your job interview they say no, but your salary is going to be 50,000. I think you can take out that advertisement and say, based on this is why I came. This was the invitation to come and negotiate, to treat. And this is why I'm here. So I think you've got relatively strong grounds to push for that higher salary. If supermarkets make a mistake, if they advertise an item for a too low price, they often stick to that price. Why? Not because it was an offer, but because of goodwill. They want that customer to be happy and satisfied leaving that shop. So goodwill with their customers, not due to legal contractual requirements. So in Fisher versus Bell, there was a flick knife advertised, and it was seen as an invitation to treat and not an offer for sale. This is how he escaped a criminal conviction, because he wasn't allowed to advertise or sell knives like that. But he said, no, I've only put it in my window to draw clients so that we can negotiate about other stuff. So it's just an invitation to treat. Just like goods on a shelf with a displayed price. This is an interesting one. In other words, if you take that article from a shelf and you put it in your basket, your grocery basket, it is not yours yet. Okay? Because that price on the shelf is not an offer. It's not an offer. It's only an invitation to make an offer. In other words, it's giving you guidelines. So when you take your article out of the shop's shelf and you go to the till to pay for it, that price that you show to the guy behind the till on behalf of the shop owner, that clerk will accept your offer because you show him the article, and that clerk will say, okay, on behalf of the shop owner, I'm accepting your offer, and there's a transaction, an agreement. Okay? So, because it's working like this, there was an interesting case, Pharmaceutical Society of Great Britain versus Boots Cash Chemists, and the Pharmaceutical Society argued that the fact that the customer could pick items out of the shelf themselves, that it was a breach of the Pharmaceutical and Poisons Act of 1933. But because they were not allowed to sell those items just to anybody, but it was found that the contract is not completed until the shopkeeper or someone on his behalf accepts the offer. The contract is not completed until the customer has indicated the articles which he needs. The shopkeeper or someone on his behalf will then accept that offer. Only then the contract will be completed. So I believe this is a revelation to several of you. This was a really interesting case, the case of Carlyle versus Carbolic Smoke Ball Company. What Carbolic Smoke Ball Company did, they've placed an advertisement saying that they will deposit or they will pay £100 to anyone who uses the smoke ball and still gets flu. Because according to them, this will immediately cure you from influenza and prevent it and prevent flu. And they said, they've already deposited £1,000 into a separate bank account so that if there's anybody that experiences after using this 3 times a day for 2 weeks, then they will pay that person that money. So when Mrs. Carlyle saw this, she went to the chemist and she bought one of these carbolic smoke balls. She used it just like they said, and then she got flu, she got influenza. And at the end of the day, I mean, you can't make a offer to the whole world, and they made like an offer to the whole world, not necessarily, even though it was open to the whole world, it was specifically addressed to that group that would use the smoke ball. So if you bought a smoke ball and you used it, that was actually consideration enough, because all the stipulations that they've used in their advertisements, Mrs. Carlyle adhered to that. So the communication of acceptance of that offer was not needed here. In this case, we talk about a unilateral agreement. In other words, where the advertisement is basically a promise. The same kind of advertisement, we get the same kind of advertisement where like the advertisement is basically already an offer. Say for example, if your dog or your cat gets lost, and you advertise that you will pay somebody that's seeking for your dog, finding it, like a certain reward, like 10,000. And if a certain person see this and they go search for your dog and they find it and they bring it to you, guess what? It was a unilateral agreement. You have to pay them. Okay? However, if they bring your dog that was lost back to you, but not based on the fact that they've seen the reward, and afterwards they see the reward, they cannot come and claim it anymore. Okay? Because they did not bring it, or they did not find it, or they did not expect that reward. It's only afterwards that they became conscious of that advertisement. So just realize that depending on the words used in an advertisement, it can be a unilateral agreement, an open offer to whoever accepts it, it will be valid. Sometimes it's necessary for us to distinguish between tenders and offers. Tenders are commonly used by government departments and big businesses. I myself was responsible for tenders, for basically the allocation of it as part of a 3-man panel. So a tender invitation will ask for proposals and costs of providing different services or goods. In other words, you place an advertisement and you invite people to tender. And then the reason why you do it, because if you invite the whole public to tender, then your choice of service provider is like big. You can really get like the best prizes, and depending on whether it's goods or services, but also you can basically have like a choice between choice providers, the best of the best. You can use the best of the best in the market. In other words, you can say, for example, in your tender that price will be one of the things that you will consider in the allocation of the final contract, but you can also leave space for kind of like quality considerations that people, if you've not specifically provided the quality agreements, because usually that's what you do, but you kind of like leave something open saying that if you disagree with this kind of stipulations that you have, you can make alternative suggestions, and then you can also take that into consideration during your allocation of your tender, of your contract. It is a way of obtaining from the marketplace a competitive range of prices and choice of service delivery. You can say in the invitation to tender that no agreement or binding legal relation is created unless a formal contract is signed. Very important, people, and you will soon see why. People, this really happened in Palmerston North. The Palmerston North City Council put out for tender the construction of a flyover. I was amazed to see that there's a council thinking of flyovers, because in New Zealand they don't build flyovers. It's always another roundabout. It's so frustrating, all the roundabouts. It's not the solution for the long term, but I don't want to become distracted. In the rest of the world, they build flyovers, so there's a good flow of traffic, but in New Zealand, it's always another flyover. So the tender documents set out detailed criteria and plans for the construction of the flyover, and were to be awarded to the lowest tenderer. That's what they said. They're going to award it to the lowest tenderer. However, there was a rival contractor who submitted a tender for the construction of a redesigned flyover, and the council subsequently accepted that tender without giving the other tenderers the opportunity to submit a tender for the new design. Okay, people, it's the council. Save a nation with this kind of council, or people in the council. After discovering all this, Pratt Contractors sued the council for damages because they tendered the lowest, and they were supposed to get that lowest tender. So it was held in the court that the city council tender was a legally binding obligation. And as a result, the city council should have given Pratt Contractors the opportunity to revise and resubmit their tender. In other words, it was already a legally binding obligation. Okay, so Pratt Contractors, who tendered the lowest amount, they should have given them the opportunity to revise and resubmit their tender. So the court awarded damages of $17,822 for reimbursement of the costs in preparation of the tender. In other words, this is what it cost this company because they spend a lot of time in preparing this tender. On top of this, they also awarded them damages for $200,000 for loss of profit. Can you believe it? So Pratt Contractors, man oh man, they got $200,000 loss of profit. In other words, they could sit at home, drink drinks. They got $200,000. So the council just wasted the tax money of all those people of Palmerston North. Sounds familiar for certain areas. I'm just thinking of places like Rotorua, but okay, that's another topic. Footnote: the judge noted that the council could have alternatively accepted none of the tenders instead. So that's why the council had to pay the $200,000 for loss of profit plus the $17,822. The question will always be, are tenders offers? And it will differ from case to case. But in this case, in Pratt Contractors Limited versus Palmerston North City Council, the question was, did the parties intend to create contractual relations? And the answer was, they did. Because the tender documents were extensive, detailed, and substantial. It was a two-stage process, and Pratt had to pay a non-refundable deposit. In other words, they were risking money. If they didn't get the tender, they would have lost that money. They had to pay for it on top of preparing it. Okay? In order not to be caught by this kind of decision, you can include a clause like no agreement or other binding legal relations will be created until a formal contract is signed. So remember that. Or the lowest of any tender will not necessarily be accepted. This is the kind of words that you can put in there in your tender, in the invitation, to basically prevent this kind of thing from happening. But unbelievable but true, but it's still happening out there. Okay, people, you have to inform the offeree of the offer. The offer must be communicated. I've already given you this example when we spoke about unilateral agreements. But you lose your cat or your dog and you offer a reward for it. If somebody sees the sign and brings your cat, that was adequate communication. They will receive the reward. But if your friend knew about your cat and not the reward, in other words, he brings somebody in the neighborhood bringing your cat and your dog, and you ask him, why did you bring it to me? And he said, I just know it's yours, but they've never seen the reward. They can't claim it. As easy as that. It should have been communicated to them. So, what can happen is if you make an offer and you decide, no, I'm not actually supposed to sell my house, but you've already kind of like said, okay, the first person who will bring you like $500,000 will get your house, you can still revoke it. But once it was accepted, if it was accepted, people, you have a contract. Okay? So if you make an offer and the offer was like presented, and yeah, like let's say for example you want to buy a house, you make an offer on it, and afterwards you decide no, I shouldn't have done it. You phone the real estate agents and saying, hey, listen, I've made that offer, and but please don't present it, and because I want it to be revoked. But if they say no, the seller already accepted that offer, there is a contract and you will not get out. Okay, so an offer lapses if it is not accepted within a certain time frame specified. Then it will lapse. In other words, you say, I'm willing to sell my car to the first person who comes, and this offer is open until the 10th of January. If somebody comes after that, the offer already lapsed. It's too late. If there's no time frame provided, people, we just talk about a reasonable time. In other words, what will a reasonable person think was like a reasonable time? It will be determined in the particular circumstances. The circumstances of each case will determine it. But let's say, for example, if there was a reward for your dog and somebody brings your dog, like 1 year later your dog goes for a stroll, he catches your dog, brings it, say, the reward is still up there. Just think for yourself, it's not reasonable. It's not a reasonable time anymore. Many people do not know this, but the effect of a counter offer is to destroy the previous offer. So let's say, for example, you see somebody advertising a car and you come with a counter offer. This person is asking you, saying, okay, Jay, you can buy my car. He's one of your friends or just somebody that knows that you're looking for a Toyota. He said, okay, you can buy my Toyota for $9,000. And you think, I'm just going to try my luck. And you tell him, okay, I'll tell you what, I'll give you $8,000. The moment that you make that counter offer, remember, then you can't go back on the original offer that he offered to you. If he's saying no, then you said, okay, then I'll have to give you the $9,000. Then he doesn't have to sell it to you anymore because your counter offer basically destroyed the previous offer. So sellers often make that one counter offer too many, and then the buyer gets buyer's remorse and reject the latest counter offer from the seller. The seller then cannot accept that earlier offer made by the buyer anymore. So people, don't be too quick. Don't think you are very wise making a counter offer, because often you will lose something and the stats are counting against you. If you accept part but not all the terms of an offer, then it is a counter offer. Okay, so it's destroying the original offer. So let's say, for example, you are in a house transaction and you think, okay, let me just, there's something small that I still want to sort out, and you say to the landowner, but what about the bathroom? I want the bathroom fixed. Then somebody else can come in and buy the house as it is. Okay, because you were basically, if you snooze, you lose, but you were busy with a counter offer and somebody else came and accepted it unconditional. So it's interesting, if you look at the National Employment Association, 80% of those people who accepted a counter offer were no longer with their company 6 months later. In other words, often it happens that you will work for your company, they don't really look after you, and then you get a job offer and your job will come with a counter offer. Okay, and it's proven all those people who accepted that counter offer were not happy. So 80% of them left 6 months later. Within that next 6 months, they left the company in any case. So long and short of the story is just say no to counter offers, because statistics are showing you that if you take a counter offer to a landlord or somebody in a transaction, somebody willing to sell something, 78% of those people will say no. Only 21% of them will say, okay, yeah, I will accept your counter offer. So making a counter offer, we often think, that's good business skills, but it's actually often stupidity. There was this interesting court case. The name of the case is Hyde versus Range. So what happened, Range wanted to sell his farm. So he was willing to sell his farm for £1,000, which was a very good deal. Then Hyde rejected that offer by making a counter offer. He said, you know what, this price is a little bit stiff. I'm willing to pay you 750,000, and later on he was willing to pay even 850,000. But the Range said, you know what, you did not accept my original offer, so I'm not willing to sell to you anymore. Hyde was furious because he was an important businessman. He went to court, and the court found, hey, there was no contract because you rejected the offer. So remember, it's going to backfire on you. These counter offers, it's going to backfire on you. It's almost guaranteed. So conditional offers are very often or very common in real estate. Conditional offers, and I've been making conditional offers myself, subject to arranging finances or a land information, a LIM report. We just talk about the LIM report. So a contract, we've got a contract, but it is a conditional one. In other words, if I say to this person, okay, I'm willing to buy this property, but based on the condition that if the bank do not want to finance me, I will not go on with the transaction. If, and you mention the name of Barclays Bank, or especially if you know the bank manager and you ask him if he's willing to, if you're not 100% sure and you want to cop out, that he will back you, or otherwise just play it honestly. I mean, do it in good faith. Do it sincerely, do it honestly. It's interesting, in this court case, Shell Oil New Zealand Limited versus WorldCom Investments, there was a series of negotiations and even an exchange of what would be in the agreement. They've decided, okay, we're going to put this and this in the agreement. The agreement was already drafted, and it was signed by WorldCom and sent to Shell. Shell just had to sign. But Shell did not sign it, and it sold the property to another party. So, of course, WorldCom was like furious, but the formal agreement was not signed, and therefore it was not a binding agreement. Shows you, people, you can't trust anybody, not even if stuff is in writing. Okay, it will have to be signed as well with the proper witnesses in the proper ways and so on. But yeah, for property contracts, we want all the evidence to be valid and legal, and we do not want to have any like improper contract as evidence. People, offer. An offer is one of the ingredients of a valid binding contract. But if there's an offer, we only have like an agreement or a contract if there's acceptance as well. And that acceptance must be, it can be like verbally, if you say, thank you for the offer, I accept it. In other words, you want to sell your car, and somebody is coming and making an offer for it, and you say, thank you for your offer. Yes, I accept it. It can be via conduct, the raising of a hand at an auction. In other words, the moment that that guy is shouting out an amount, guess what? Yeah. And, or you just, and they know, okay, you're willing to pay that amount. Or it can be written. So, like I've said, property, when we work with real estate, that contract has to be in writing. The vendor signing the written offer that was made to purchase her home. So somebody wants to buy my home, make me an offer, and the moment that I've signed it, yeah, I'm accepting it. Yes, that's acceptance. And the law will acknowledge that acceptance. Remember, I told you law does not exist in a vacuum. We build, it's like evolution, it's like building, we build on previous foundations. And so there's always developments. So if we look back in history, we will see that there was like a old postal rule. In other words, the offer was deemed to be accepted when the acceptance letter was posted by the offeree, and not when the offerer receives it. So it happened in several cases that let's say, for example, I want to sell my house, and somebody will accept that offer and post the letter saying, I'm accepting this offer, and maybe even communicate it to you, and you after a while think, this person is just wasting my time. You sell it to somebody else, and then the letter arrives. And that moment that the letter was posted, that's the English postal rule. I mean, if that person's got evidence that he posted that letter, guess what? That was the time of acceptance. Okay? So the Electronic Transactions Act of 2002 has been repealed, and it's now absorbed into the Contract and Commercial Law Act of 2017, Part 4, Subpart 1. So its purpose is to facilitate the use of electronic technology, okay, by reducing uncertainty, because there was a lot of uncertainty regarding the legal effect of information in electronic form, and the time and place of dispatch of electronic communications. And it's also providing how certain paper-based legal requirements may be met by using electronic technology. In other words, it's now modern. We want to use electronic technology. So the postal rule still applies, but it's now combined with new thinking around when a contract is formed and what terms are included in it. So if you look at section 213, you will see that the question is, what time is an electronic communication taken to be dispatched? And according to section 213, it's taken to be dispatched the moment when that electronic communication first enters an information system, and the moment that it is outside of the control of the originator. So, what time is an electronic communication taken to be received? The time of receipt. It's an electronic communication is taken to be received in the case of an addressee who has designed an information system for the purposes of receiving electronic communication at the time the electronic communication enters that information system, or in any other case at the time the electronic communication comes to the attention of the addressee. So Long and short of the story is, if you and I, if we are negotiating about there's a certain transaction that we're busy with. The moment that I click send, yes, I'm accepting your offer, that's acceptance. Because then it's out of my control. It's just like that person that posted the letter, okay, in the past, in history. So the time of receipt, okay, that moment that message, when you clicked send, when it went into the system, in the electronic communication, when it entered that information center, that's basically the time of reception. Okay, so on the other hand, even if it goes to your spam folder, or whenever you when it enters your system, people, it's part of it. It's part of reception. Okay. Whenever it comes to the attention of the addressee. In other words, you don't necessarily have to see it. Your secretary can just tell you, "Hi Jay, there's an email of acceptance," or if she told you something, or an email from Mr. So-and-so, if you ignore it, it's your problem, okay? But according to the law, it was a time of receipt. You've already received it, accepted it. Okay, it was already accepted, but it's already in your, you've already viewed it. It's very difficult because it's new stuff. All this computers and so on. And so often in the past, if something happened in a certain area, we knew exactly which court will have like jurisdiction. If you now send an email, maybe you go overseas and you go to Canada and you send an email to somebody over here accepting his offer. Okay, it doesn't matter whether you've been in Egypt or wherever you've been. The fact that you've been in Canada has got nothing to do with it. According to section 215, that communication will be taken to be dispatched from your place of business. And if you have more than one business, that business that's got the closest relationship with the transaction into that we've got into consideration. Same thing, where is an electronic transaction taken to be received? Same thing, it doesn't matter whether you're in Canada on holiday or in Singapore. I mean, they will take your place of business as the address. And if you've got several businesses, the most relevant business to this transaction. So people, when it comes to section 217, it's basically just confirming the moment that you entered that email, the moment that you clicked send, that was the moment that you've accepted that offer. So you covered there, but it's saying, hey, sometimes you can negotiate. There's room that you can negotiate the time of acceptance. In other words, you both of you can make an arrangement and saying, okay, in this case, it will not be that moment that I send it. It will be 2 weeks later, or 1 month later if I do not change my mind. If I don't change my mind within 1 month, then you can negotiate something like that. And the room that you have for that is section 217, subsection 2. Electronic communications are valid, but subject to the rules of all other types of contract: offer, acceptance, consideration, intention. People, the question nowadays is because more and more people want to use electronic signatures to agree to a contract. So electronic signatures are dealt with in Section 226 of the Contract and Commercial Law Act of 2017. And it basically states that a legal requirement for a signature other than a witness's signature is met by means of an electronic signature if the electronic signature adequately identifies the signatory and adequately indicates the signatory's approval of the information to which the signature relates, is as reliable as is appropriate given the purpose for which and the circumstances in which the signature is required. In other words, if it adequately identifies you and indicates your approval, and it is reliable for the purpose, because if I have to sign stuff, I'm sitting here, you know. In New Zealand, even though I've got dual citizenships, I'm also a citizen of South Africa. I never gave up my previous citizenship. However, a legal requirement for a signature that relates to information legally required to be given to a person is met by means of an electronic signature only if that person consents to receiving the electronic signature. In other words, it all depends on the party on the other side. If that party is saying, no, 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 I want your original signature because I'm worried about fraud and I don't want to go to court and so on. If they refuse to accept that electronic signature, guess what? Bugger. Yeah, you sit with a problem. But if they accept it, then it can work quickly and it can work fine. Some places want originals, but nowadays, due to the scan facilities and so on, I sign documents over here and scan it in. So can you see that the law has not reversed what has come before it? Because if you think in terms of the Old English postal rule, but rather it moved to keep it relevant. In other words, it developed. It's good developments. People, the Contract and Commercial Law Act of 2017 covers the issues that develop due to the electronic age, and it regulates the effect that it has on the traditional way of doing business. One interesting legal evolution that we just discussed is that is continued in the Contract and Commercial Law Act of 2017 is the use of signatures to show agreement. And this is interesting. If you look at advertisements, how everything is progressing. Over here it's saying, which tool, just look at this slide, which tool is your business using? And then you will see the 20th century business tool. It was a book, okay? But the 21st century business tool, over here, it's electronic signatures. It's interesting. Just think of all the paper that you can save and look at the courier services. The courier services, nowadays, they ask you to sign on that device. It's actually amazing. Most of those devices are touch screen and you can sign on it. In other words, we are evolving. Law is moving forward. Or as there's new developments, law must make room for those developments. People, we've already been talking about consideration, and the moment that you see this word consideration, think about it as money, as something, as some kind of reward. Okay, people, we know that there should be intention to be legally bound. We've spoken about an offer. You know everything about an offer now. We've talked about acceptance, how we should accept something and when is the time that that offer is actually accepted and the agreement is actually coming into being, the contract. And now we want to talk about consideration. That's the third ingredient. Basically, we will talk a little bit more about intention. But both parties must receive something of value in New Zealand, because if you go to South Africa, I mean, it's not an element. If you go to Scotland, there's many countries, they don't mind. Consideration is not part of it. You can basically give your house away in a contract. You can put it in writing. I give my house to you, basically. Yeah. So that other person do not have to give, like, there doesn't have to be anything of value. Okay. So the main thing that you have to realize over here in New Zealand, the consideration does not have to be equal. The courts are not interested in the size of the consideration. They are only interested in the presence of consideration for now. Okay? So, our New Zealand courts, for an offer to be enforceable, there must be consideration. If the parties wish to be bound by a contract where there is no consideration, whenever there's no consideration, let's say, for example, I want to gift my furniture to somebody. I can sign a special document that we call a deed. Okay? And then we don't need consideration. Okay? Because that will also be enforceable. There was an interesting court case, Dunlop Pneumatic Tyre Company Limited versus Selfridge and Company Limited. So in the contract, Dew and Company wholesalers, okay, they agreed to buy tires from Dunlop. So remember, Dunlop is the main provider. So Dew and Company wanted to buy tires from Dunlop, and Dunlop said, okay, yeah, we based on the following conditions. The express undertaking that Dew and Company wholesalers would not sell below certain fixed prices. They said, okay, but remember, there's certain fixed prices and you're not going to go below it. Okay? So Dew said, no, I want your tires. I really want you to buy your tires, so no problem. They also undertook to obtain the same price fixing agreements from their clients. In other words, they said, okay, and if you have clients, they have to follow the same agreement. If they buy tires from you, the tires that we provide to you, they have to follow the same agreements. So Dunlop was just making sure that Dew and Company could not sell it at a very low price through another company or through another friend's business or whatever. Dew sold tires onto Selfridge on these terms, but Selfridge broke the agreement and sold tires at the discount price. Okay, and they were not allowed to, because that was an agreement that Dunlop made with Dew and Company, and Dew and Company had that same agreement with Selfridge, but Selfridge took a chance and Dunlop sought an injunction. In other words, an injunction to immediately stop them from continuing with this. Okay, and they were successful. So this is what the court case was all about. In other words, in this example, the consideration for getting the cheap tires was that promise. We will not sell below that certain level. So consideration can be something like that, not necessarily money only. So people, in this court case of Dunlop Pneumatic Tyre Limited versus Selfridge, we've seen that even a promise can be like adequate consideration in light of the circumstances. So the mentioned case was followed in New Zealand in Rothmans of Pall Mall. Rothmans of Pall Mall Limited versus Attorney General. The court found that there was no consideration on Rothmans of Pall Mall's side. So what happened over here? He lost his advertising privileges, even though it was promised in the past that he could go on the way that he did. In other words, the Crown basically promised him, guess what? Rothmans of Pall Mall, you can go on with your business and we will never intervene. And guess what? It was decided, because then they stopped it. And then it was decided that the Crown cannot limit Parliament in an agreement not to pass certain legislation, because they brought out legislation saying, hey, you can't advertise anymore that cigarettes are healthy or good for you or whatever. We want to stop the advertisements, and Rothmans of Pall Mall said, but here we've got it in writing. And the Crown simply said, no, it's Parliament and we can't do anything about it. Okay, so yeah, it shows you, it's very difficult to, if you work with politicians, if they're sovereign, you can't basically rely on anything, like we've seen just. Okay, consideration is described as the price paid by the plaintiff for the defendant's promise, or alternatively, the granting of a benefit on the defendant by the plaintiff in return for the defendant's promise. Okay, so that was what was decided. The price paid was the defendant's promise in the case of Dunlop Pneumatic Tyre. Okay, but the other one, like I'm saying, the Crown said they can't limit Parliament, and Parliament decided to pass legislation that Rothmans and Pall Mall couldn't go, or any cigarette companies for that matter, couldn't go on with their advertising. The question is often, what exactly is consideration? It's the exchange between parties to a contract of something that is valuable to them. In other words, I've taught you in the past, you should always remember, in any transaction, there's always a certain right that you have and a certain obligation. And the other party also have a right to something, but also an obligation to something. Okay, so if I buy a chocolate, I've got the right to receive the chocolate, but I've got the obligation to pay for it. And the person selling the chocolate, they've got the obligation to give me the chocolate, but in exchange, like I say, they've got the right to get their money. So can you see there's always rights and obligation, a right and the obligation for both parties in commerce. So the same thing is true for contracts. So the exchange between the parties to a contract of something that is valuable to them, that's consideration. And something that can be that can count as consideration is, for example, services. Okay, Jay, I will, if you come to my massage parlor, I will massage you, but then you wash my car. Something like that, because usually people pay me for my massage services, but if you wash my car, it's okay, I will accept it. Or goods. can be, if you give me, okay, give me your watch. If you can't pay me, give me your watch or your cell phone. Sometimes consideration can just be something that you sacrifice, something that you're giving up, forbearance. Or it can even be real property. It is what is swapped for the promise in a contract. And the courts have already described it as an act of forbearance of one party or the promise thereof. That's a price for which the promise of the other is bought, and the promise thus given for value is enforceable. Okay? So just think about all the transactions that we do. I mean, you go to a shop and you know the shop owner, and there's a book, say for example, or even if you buy stuff on credit, you promise to pay for it. That guy is not getting the money, but you've promised to pay for it at the end of the month or at the end of the year or whenever. And based on that promise, you can walk out of that shop with your article. That's how powerful a promise is. Unfortunately, if we look at economics, we're in a big bubble because everybody is relying on promises, and the more promises we make, the bigger the bubble becomes because it's not real money. But that's, of course, economics. We're busy with law, so I'll stick to law. You can buy a chocolate and pay for it. The value is the money and the chocolate respectively, though. So you see a flow on both sides. The actions, goods, or real property from another, it's all parts of consideration. And remember, consideration is never one-sided. Someone promised to leave their garden set to you when they relocate. Guess what? If they don't do it, you cannot sue them if they do not do it. Why? Because what was the consideration that they received? If you can, if somebody is saying, I'll leave my garden set to you, and you say, okay, under one condition, take this $5. And I just want to pay for it now. People, then there was consideration. Okay, even if the $5 is way smaller than the garden set, but then there's like a legal contract because then consideration is present. So just make sure that consideration is present. There's different types of consideration. Like I've told you, you can say that you're going to pay something at a later date and it will still be seen as consideration. In other words, it doesn't have to be immediately. It can be immediate, the passing of hands. In other words, if you buy something for cash, if you go to the cafe and you buy a coffee, or like I say later with promise, then in law, we get like executed consideration. This is when the exchange of value has been completed. In other words, the consideration was executed, it's finished, you paid for the coffee, it's paid for. Executory consideration, when there is still a promise to pay or perform at a later date. So whenever you see that difficult phrase for me, in any case, executory consideration, you should know that there's a promise to pay or perform at a later date. It's not executed yet. People, how much consideration? The value must be valuable and real. In other words, you must be able to prove that there was really value in what you offered or what you wanted to receive. It should just be a good bargain. And it's not for the courts to decide if it was a good bargain. If it was a good bargain for you, it's okay. So there's no commercial or personal weighing up in the court, as it is subjective. unless one party is a minor and there's fraud allegations. In future, in other words, remember, for now when we work with contract law, remember, we are only interested, the court is only interested in the presence of consideration. But guess what? We don't want fraud. We don't want to fool people, especially when we work with minors and so on. And so in certain situations, the court will look at the value of the consideration. But when it comes to contracts, remember there's a say in law, you should allow a fool to be a fool. So one man's rubbish is another man's treasure. I'm saying it over and over again. The court is only concerned with the presence of consideration. It's interesting, there was this court case where Nestlé did not allow people to sell at retail. Or Nestlé was not allowed to do it, you know. And so because they did not have like a copyright. And when you had like, if you did not have copyright, you could not sell at retail. So what Nestlé did, they said to people, okay, if you bring us 3 chocolate wrappers, you know, that's adequate consideration so that you can have like the privilege to buy stuff at copyright. So when Chappell finally took them to court and saying, hey, you selling at retail? No. They said, no, our price is not retail price. Our price is retail plus 3 chocolate wrappers. So they said, but chocolate wrappers has got no value. People throw it in the rubbish bin. It's still, you're still breaking copyright, you know, and you're still trespassing the law, you know. So Nestlé said no. And guess what? The court decided in Nestlé's favor. Yeah, that 3 chocolate wrappers was adequate consideration to consider to not make it selling at retail anymore, you know. So the Court of Appeal in Malmary Investments versus McGarry, a court is concerned only with the presence of consideration. That's what they found in that court case, and we've mentioned it 10 times now. Maybe not really 10 times, but several times. It does not make an assessment. The court is not making an assessment of the comparative value of the acts or promises of the 2 parties involved in that transaction, or the promises of the parties towards one another. Okay, so the court is not doing that. The court is only interested in the presence of consideration, not the size of consideration. Okay, people, Chappell and Company versus Nestlé. Here is basically the material facts of the court case, basically what happened over there. And it's just interesting to quickly read it. So I will advise you to stop the recording and read it. It's really interesting to see how clever Nestlé was, because they knew the law, and their 3 chocolate wrappers allowed them to save that money, that 6.25% that they had to pay over. People, I've told you exactly how to quote a court case, and there's always like this 2 parties. Let's say, for example, Maxine versus Poyney in a civil case. But sometimes the court can look at a matter where there's like only one party involved. So whenever you see that word re in rea, is a Latin phrase meaning in the matter of. When in rea appears in the title of a court case, it means that the judicial proceeding may not have formally designated adverse parties, or it is otherwise an uncontested matter. So the use of in re refers to the object or person that is the primary subject of the case. So if you see something like Rea McArdle, it simply means in the matter of McArdle. Usually it's got to do with when there's like bankruptcy, then we talk about if, say for example, if J is going bankrupt, Rea J, in this matter of J, or when there's mental illness, Rea Peter. Okay, in this case of Peter, when it's about his mental illness. In other words, the court have to decide. So about this matter where there's only one party involved. So, but that's really very seldom, very often, and or very seldom, and most of the times, I mean, the majority of the times, there's always like two parties, like almost always, okay? Or the court must decide about an issue, and there is no other party that can contravene a contract. Then you will see the court case like Rea McArdle. People, invalid consideration, if we talk about invalid consideration, immediately we think in terms of past consideration. So past consideration works like this. Let's say, for example, I hear you talking to one of your friends and you're saying, I want my fence painted. I'm going to get somebody to paint my fence. So you go on holiday and I decide, okay, I'm going to paint your fence. And I paint your whole fence, and when you come back, you are so happy that you say to me, Jay, I'm so glad that you've painted my fence. I wanted to get a contractor, so now I'm just going to pay you that money. Okay? And even if that person is putting it in writing but not doing it, guess what? It is past consideration. You can never use past consideration as payment or as consideration, as evidence of consideration in a contract to make it like valid. So a motorist tows you to town when your car broke. When you arrive in town, he asks you for $100 for his expenses. You agree, but this is not enforceable, okay? Because like I've said, he's asking it afterwards, okay? And that's past consideration, okay? So even if you say, okay, now I'll pay you, and you don't do it, he can't do you anything. He's got no right to that money. But let's say it was the other way around. Your car is braking, and a guy stops next to you, and he's saying, can I help? You say, please tow me to town. And he'll say, no, I'm not going to do that. I will, but then you have to pay me $100. If you say yes, then guess what? Then you're not going to get away because they first arranged it. Okay? So to come back to Rea McArdle, this court case, it was interesting. The case of Rea McArdle, the court basically decided about this issue because what he did, he maintained a family property. Okay? And the other family members afterwards, when they discovered it, they acknowledged his expenses, and they promised him, hey, you know what? We will pay you back after mom died. And then they never did it. And he was angry, but the rest of the people said, it's past consideration. Okay? And the court agreed it was past consideration. In other words, the reason why he was the only party involved in this, because they couldn't even open a court case. against those people. Even though he tried everything in his power, he couldn't even take them to court because there was no case in any case. Because there was no consideration. It was past consideration. So keep that in mind. So a public duty that already exists can never be a valid consideration. People, very important. Let's say, for example, you work, let me think of a good example. But let's say, for example, you work for the council and your job is to clean certain buildings, to go clean their windows. On your way there to clean building B, somebody stops you and saying, hey, you did not come and clean building A's windows last month. Guess what? I'm willing to pay you $50 if you come and wash those windows. Basically, that person is already being paid to do it. So that's an existing thing. It cannot be, if he's washing the windows for you and saying, give me that, and you say, no, I don't want to. He said, I'm always washing these windows. But he's getting a salary for it. So it's an existing duty. It can never be valid consideration. So keep that in mind. I hope I make myself clear on this one. If not, tell me and I'll change it. Even though we spoke about it several times, I want you to tell me what exactly is intention. Intention. If you look at this, our intention creates our reality. It's just something that I got on Google, but it's so true. You can have a certain intention, and that's basically creating your reality. Let me explain to you something. Let's say, for example, you've got the intention to go and murder a certain person. When you get to that place, you take a brick and you throw it through the window to break the window so that you can go climb inside the house to murder this person. But this person, guess what? There was a gas leak and this person would have died if it wasn't for you breaking the window. And at that very moment you hear somebody coming, so you're running away. They discovered your fingerprints on it and they've realized, you were the one saving this guy. Are you a hero? Can you see? Intention matters. Intention is very important. And this is in law why we often talk about good faith, and the opposite of good faith is bad faith. The intention that you had in mind when you did certain stuff. If you are sincere, you have good faith. And we need people in life who are sincere and honest and open and transparent. But if a criminal has got like an intention, a bad intention, a criminal intention, we call it mens rea. And it describes the mental thought of knowing that you are doing something wrong, as opposed to the action of actually doing it. Okay? So equally important in contract law is this knowledge and wish that you will be bound by the agreement and terms of the contract. In other words, the reason I've explained to you why your intention is so important, because there might be a misunderstanding. Maybe you don't even know that you're signing a contract selling your house, because this guy is telling you you just have to sign this contract because it's a package that will be delivered to you. Maybe it's after your husband died or something like that, and you are emotional and you didn't read the contract. You had no intention to be bound by that contract. Okay, so the courts look for what the intention of the parties was in deciding if there was an offer or acceptance. You must want to be bound by that contract. In other words, yeah, that was my intention. I wanted to sign that exactly like it's saying. If you are just making a joke, you don't have the intention to really be bound, okay? You must look at the fact of each case. And the relationship between the parties are extremely important. You will see at the end of the day, when we look at intention, it all comes back to relationships. Because there's like the courts, usually if it's like a business relationship, they will say there was intention. But if it's like an agreement between family and friends, there's always the presumption that you, at that moment, you did not think that you will take your friend or your family member to a court. You never had the intention to be legally bound by that agreement. So that's really important. So there's a presumption if it's like a transaction between friends or family that you never had that intention. Of course, all presumptions can be proved wrong. In other words, we can prove the opposite. But remember, the place where we will start in a court case, no, you did not have the intention to be bound because he was your friend. You didn't at that point in time. You were not thinking of, if he's not sticking to the agreements, I'm going to take him to court. No, that friendship is too important for you, or even a family member. That family blood relationship is too important for you. That's what the presumption of the courts are. People, like I've told you, courts are very reluctant to find a valid contract in family arrangements. In the court case of Fleming versus Beavers, Beavers claim half of the house and the piano from a de facto partner that died and left everything to his children. She claimed that they had a contract. The court found that there is a greater chance of there being a contract between strangers, and indeed an inference can be drawn from that fact that there is intention. The court found that there is a possibility of intention, and she, at the end of the day, received half of the house, but she never received the piano. So remember, this guy, he left everything to his children. That was his wish. And then she fought it. She said, no, he wanted me to have like half of the property. But nowadays, the possibility of a valid contract between spouses, de facto partners, or those in civil unions, it is recognized by Section 47(3) of the Property Relations Act of 1976. People, friendships can easily be ruined by money. So it happened in this case. Remember, there's always this presumption against there being a contract when we talk about friends. Okay? So this presumption will be tested against the subject matter of the contract and the circumstances surrounding the alleged making of the contract. So all these court cases, there's always somebody that's saying, there was a contract, and then the court will say, but it's between friends. There's a presumption that you never had the intention to be bound, so there wasn't a contract. Okay? But remember, those presumptions can be proved wrong. So what happened in Simpkins versus Pays? Pays and her granddaughter plus Simpkins, who was a boarder, agreed to contribute to buying a lottery ticket. And after they bought it, guess what? They decided, okay, they're going to share the profits. But Pays and the granddaughter decided not to share with Simpkins. They decided to use all the money for themselves. Even though it was between family and friends, the fact that Simpkins was a paying boarder made the difference in this case. So if she didn't pay, if she was just staying with him in that house, guess what? She would have lost. She wouldn't have been able to share in that lottery profits, but luckily she paid, and because she was a legal boarder, she was able to share in the profits. The case of Balfour versus Balfour is interesting. In this case, it was found, the court held that there was no intention to be legally bound. So the material facts of this case were as follows. The Balfours were living together in Sri Lanka. Previously we called it Ceylon. And Mr. B had a job there. He was an engineer. So they visited England, and Mrs. B contracted rheumatic arthritis. The doctor's advice for her was to stay in England, and Mr. B left for Sri Lanka. But he promised to pay Mrs. B £30 a month until she would be able to join him. But after a time, this payment stopped, and Mrs. B took action in courts. The courts found, hey, it was only a promise. It was never intended to be a contract because it was between family members, you know. But it was just part of the usual husband and wife discussions. So she couldn't do anything. It wasn't a contract. Okay, what happened in Balfour versus Balfour? Almost a similar thing happened in Merritt versus Merritt. So what happened over here, Mr. Merritt and Mrs. Merritt, they kept a property. It was in their names jointly, so they owed it jointly, but it was still not paid for. So then Mr. Merritt decided to divorce his wife. And he said, okay, I will give you £40 per month, which was a lot of money in those days. And he said, but under one condition, you have to pay the mortgage with that money as well, and you have to, and she said, okay, I will pay the mortgage, but under one condition, if I fully pay it, because it's going to be tough for me, then the house is mine. So he agreed with her. He said yes, because he divorced her for another woman, and he went and lived with this other lady. Okay? And so eventually, when she wanted to register the property in her name, he refused. He said, no, 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 no. That property actually belongs to us both. And then she fought it in court. And he said, but there was no consideration. She said, remember all the years that I had to pay it, that I struggled to survive due to those installments. That was basically my consideration, and the courts agreed with her. And he also said, but there was no intention for a contract to be formed because we are family. I mean, it's like a family arrangement. So the courts decided no, because he already moved out to stay with the other woman. He already divorced her. The moment after he divorced, this happened. They said, so therefore it wasn't like a family matter anymore. So there was the intention, you had the intention to be bound by it. And so luckily Mrs. Merritt got the property, and he got his woman that he walked away with. When we do not work with families in business, the presumption is always that the parties did intend to enter into a binding contract. A case where this presumption was rebutted was in J.A. Milner and Son versus Percy Bilton. A law firm argued it reached an agreement with a property developer that they would be doing the legal work on a development, but the language used in the document was so vague that at the end of the day, it did not show an intention. So guess what? If you want to prove intention, you have to have like evidence. There was also this court case of Wakeham versus Mackenzie. There was like a oral contract that the plaintiff should get the deceased house after his death. That's what she said, and she claimed it in court because then the house didn't really put it in her name. So according to the will, it wasn't going to her. And what she did, there was part performance on her side. She gave up a flat and she went to live with the deceased, and she was looking after him and looking after the house. And all this was adequate consideration. It was specific performance. And so guess what? She succeeded in maintaining the property. So here's all the material facts of it, because I just basically touched it in the previous slide. But after his wife's death in December 1963, B, who was 72 years of age, orally agreed with the plaintiff, who was a widow and 67 years of age, that if she would move into his house and look after him and for the rest of his life, she should have the house which he owned and the contents when he died. It was a term of the agreement that he should pay her for her own board and coal. The plaintiff gave up a council flat and moved into B's house. She looked after it and looked after him until he died, and she paid for her board and coal. B died in February 1966. He did not leave the house or contents to the plaintiff. Can you believe it? An action by the plaintiff for specific performance followed, based on the specific performance of the agreement. It was held in court, the giving up of the plaintiff's flat in order to make her home at B's house, her moving into that house, her acts of looking after B and the house, and in paying for a board and coal were acts of part performance which must be referred to some contract, and were referably to the contract that she alleged. Accordingly, the court would decree specific performance of the oral contract by B with the plaintiff that she should have his house and the contents after his death. So it was an oral contract, but nevertheless she got the property, everything.